Number 5. Darren Roy. He had everything: a successful business, a wealthy family name, a lakeside home in one of Nevada's most affluent communities, and on the morning of June 12, 2006, he threw all of it away with a knife and a rifle in a single day of calculated violence that shocked not just Reno, but the entire American legal system. Darren Mack was not the kind of man people imagined when they imagined a killer. He was the co-owner of Palace Jewelry and Loan, a family pawn shop dynasty his mother had built into a thriving business. He had grown up in Reno, attended the University of Nevada on a baseball scholarship, moved in social circles that attended charity galas and business dinners. He was, by every surface measure, a success. But by the spring of 2006, Darren Mack was consumed. His marriage to his second wife, Charla, had deteriorated into one of the most bitter and expensive divorces in Washoe County history. The proceedings were presided over by family court judge Chuck Weller, a respected jurist Mack had come to view as an enemy, someone he believed was corrupt, biased against him, and systematically destroying his financial life through alimony rulings and custody decisions. Mack began organizing his rage. He connected with an online community of men who shared his grievances about the family court system. He stockpiled resentment. He planned. On the morning of June 12, 2006, Charlamad arrived at Darren's Reno townhouse to drop off their young daughter. Prosecutors said what followed was not an argument that escalated, it was an execution. Charla, 39 years old, was stabbed to death in the garage. She was struck 6 times. Then Darren Mack drove across town to a downtown parking garage. He positioned himself with a high-powered rifle at a window that had a direct sightline across the street to the third-floor chambers of Judge Chuck Weller at the Washoe County Courthouse. He waited for the judge to appear in view. Then he pulled the trigger. The shot struck Judge Weller in the chest. It was not fatal, but it was meant to be. Police responded to reports of a sniper. The courthouse was locked down. The city of Reno, in that moment, did not know if a mass shooting was unfolding. Mack fled. He drove toward California, abandoned a vehicle, and ultimately made his way to Mexico, specifically to the resort town of Puerto Vallarta. A pilot spotted him there. The FBI closed in. Mack eventually surrendered on June 22, 2006, and was returned to Nevada the following day. What followed was a legal saga of its own. Mack consistently insisted the killing of Charla was self-defense, that she had attacked him first. He maintained that shooting Judge Weller was a form of justified political redress against a corrupt system. His attorneys negotiated aggressively. Just as his jury trial was about to enter the defense phase on November 5, 2007, Mack abruptly pleaded guilty to the first-degree murder of Charla Mack and entered an Alford plea acknowledging sufficient evidence existed on the attempted murder of Judge Weller. District Judge Douglas Herndon sentenced him to life in prison with the possibility of parole after a minimum of 36 years. He also received 40 years for the attempted murder to run consecutively. In 2008, a civil jury found him liable for Charla's wrongful death and approved a staggering $590 million judgment against him. Mack has filed multiple appeals, all of which have been denied, including appeals that reached the Nevada Supreme Court. A federal court case filed in later years claimed his original legal team failed him by accepting a plea before evidence was presented, a claim his original attorneys have denied. He is eligible for parole in 2042. He will be 81 years old. Judge Chuck Weller, who was shot through his own courthouse window while doing his job, recovered from his wounds and returned to the bench. The question legal scholars have raised but never fully resolved: Darren Mack shot Judge Weller from a prepared position in a parking garage, a location he had scouted in advance, with a rifle he had pre-positioned. The prosecution argued, and the plea acknowledged, that this was a deliberate assassination attempt. Mack has never publicly explained what, if anything, would have happened next, whether there was a plan to continue or whether Weller was the only target. His communications in the days before June 12, 2006 were never fully made public. Number 4. Jose Vagoa. He had been trained by one of the most formidable military organizations on Earth. He had survived things that would have broken most men. And when he arrived in Las Vegas, he brought all of that training, all of that discipline, all of that capacity for violence, and he pointed it at the Strip. Jose Vagoa was born in Cuba and served in the Cuban Revolutionary Armed Forces, where he received commando-level military training. He later trained further through Soviet-affiliated programs, the kind of instruction designed to produce soldiers capable of operating under extreme pressure, executing complex operations in hostile environments, and making split-second lethal decisions without hesitation. He immigrated to the United States, eventually settling in Las Vegas. And then, beginning in 1998, he went to work. Vagoa assembled a small crew, his brother-in-laws Oscar Cisneros and Pedro Duarte, and an associate named Luis Suarez. What they executed over the next 2 years was not the clumsy desperation of ordinary criminals. It was a campaign, methodical, rehearsed, military in its precision. The casinos came first. In 1998, Vagoa's crew robbed the MGM Grand, then the Desert Inn, then the Mandalay Bay, then, in one of the most brazen daylight robberies in Las Vegas history, the Bellagio, where Vagoa himself vaulted over a cashier's counter and scooped $160,000 in chips into a bag without bothering to wear a mask. The crew netted nearly $600,000 across the casino heists. Then came the armored car jobs, and with them, murder. In March 2000, Vagoa's crew targeted an armored vehicle making a pickup outside a Ross Dress for Less store in Henderson, Nevada. The guards, Richard Sosa, 47, and Gary Dean Prestige II, 23, were performing a routine cash collection. They had no realistic way to anticipate what was coming. Vagoa shot Richard Sosa twice. He shot Gary Prestige 7 times. Both men died at the scene. The total take from the robbery was approximately $5,000. $5,000. 2 human lives taken by a man with military training for $5,000. The Bellagio robbery proved to be Vagoa's undoing. Surveillance footage captured his face clearly, the face of a man who had decided he was untouchable. The FBI identified him and began to close the net. On June 7, 2000, agents and officers approached Vagoa's residence. He fled in a vehicle, leading law enforcement on a chase reaching speeds of 100 miles per hour through Las Vegas streets before he was apprehended. While awaiting trial in the Clark County Jail, Vagoa attempted to escape. He had used a metal mirror frame to chisel a hole through his cell window, apparently intending to drop 30 feet to a sally port and then another 20 feet to the ground. The attempt was discovered before he could execute it. In June 2002, rather than risk a death penalty verdict, Vagoa pleaded guilty to all 46 counts against him: first-degree murder, attempted murder, armed robbery, and more. In his plea statement, he offered words of remorse. The chief deputy district attorney said the words rang hollow. In August 2002, District Judge Kathy Hardcastle sentenced him to 4 consecutive life terms without parole, plus 306 to 760 additional years. The prosecution had deliberately structured the sentence to ensure that even if the murder convictions were overturned on appeal, Vagoa would never leave prison. He is the subject of a 2009 national best-selling book, Storming Las Vegas, for which he cooperated with author John Huddy from his cell, providing journals, sketches of robbery scenes, and detailed accounts of the crimes. Gary Prestige Sr., father of the 23-year-old guard killed outside that Henderson store, said at sentencing, "I just hope these people, this man, never gets a chance to hurt another family. He not only killed my son, he's killed me too. The verified detail that reframes the entire operation. Vagoa's crew, on at least 2 occasions during the casino robberies, jumped into the wrong getaway cars, hot-wiring vehicles, and only realizing afterwards that they had grabbed the wrong ones. The most dangerous criminal operation Nevada had seen in decades was, in those moments, improvising. The military-trained commando who executed 2 men with cold precision had also, more than once, grabbed a stranger's car by accident. The planning was extraordinary. The execution was not always.
Number 3. Gerald Armand Gallego. There are crimes that shock because of their ferocity. There are crimes that shock because of their scale. And then there are crimes that shock because of how long they continued, because no one stopped them, because no one saw them coming, and because the man committing them was hiding behind the most ordinary possible disguise, a relationship. Gerald Gallego spent 2 years, from 1978 to 1980, hunting human beings alongside his common-law wife, Charlene Williams. Together, they are responsible for the deaths of at least 10 people across California, Nevada, and Oregon. He was executed for none of them. He died of cancer in a prison medical facility at 56. Gallego was born in Sacramento in 1946. His father, Gerald Gallego Sr., was the first man executed in Mississippi's gas chamber, a fact that lends the story a grim, almost literary quality of inherited violence. Gerald Jr. accumulated 7 felony convictions by his early 30s. He was married 5 times. He was, by the time he met Charlene Williams, a man whose entire life had been organized around domination and control. Charlene Williams was 21 when she met Gallego. She had been through 2 marriages, struggled with drug use, and was, in the assessment of investigators who later studied her psychology, someone who had been entirely subsumed by Gallego's influence. Whether that constitutes explanation or excuse remains disputed. Gallego's stated fantasy, the one Charlene later testified to in court in chilling detail, was finding the perfect sex slave. Not one, multiple. He wanted to abduct young women, assault them, keep them until he tired of them, and when they refused or resisted or simply became inconvenient, he killed them. The first known victims were Kippy Vaught and Rhoda Schaeffler, abducted in Sacramento in 1978. Then Brenda Judd, 13, and Sandra Colley, 14, taken from the Washoe County Fairgrounds in Reno in 1979. Then Linda Aguilar, 21, on an Oregon highway. Then Virginia Mockel, abducted from a bar in the Sacramento Delta. Then Craig Miller and Mary Beth Sowers, a young couple taken after a college fraternity dance in Sacramento in November 1980. And then Karen Twiggs and Stacy Redican, both 17 years old, both abducted from a shopping mall in Citrus Heights, California, in April 1980. Gallego drove them to Nevada, specifically to a remote canyon near the small town of Lovelock. Charlene later testified that the girls refused to comply with Gallego's demands. He killed them with repeated blows from a hammer. Their bodies were found in a shallow desert grave in July 1980, months after they disappeared.
The unraveling came in November 1980 at a fraternity party. Witnesses got the license plate number of the van as Miller and Sowers were taken. The Gallegos fled across state lines, evaded a manhunt for weeks, and were finally arrested in Omaha, Nebraska. Charlene Williams agreed to testify against Gerald in exchange for a plea deal that would see her serve 16 years and 8 months. Gerald Gallego was tried first in Nevada for the Twiggs and Redican murders. In June 1984, a Pershing County jury convicted him and sentenced him to death. He was then tried in California for the murders of Craig Miller and Mary Beth Sowers and received a second death sentence.
He was transferred to Ely State Prison's death row, where he spent 18 years maintaining his innocence and filing appeals. In 1997, Nevada's Supreme Court overturned his death sentence on procedural grounds, only to reimpose it 2 years later after a new penalty hearing in 1999. Throughout his time at Ely, he was described by prison medical staff as a quiet, unremarkable inmate. The man who had terrorized 2 states for 2 years became, behind the walls of a maximum security prison, invisible. In March 2002, severely ill with rectal cancer that had spread to his liver and lungs, he was transferred to the Nevada Prison System's Regional Medical Center in Carson City. He died on July 18, 2002, 1 day after his 56th birthday. Charlene Williams was released from prison in 1997, having served her full sentence. She moved back to California. She has maintained a low public profile ever since. The documented fact that haunts this case most deeply: Gallego was never tried for 6 of the 10 murders attributed to him. Karen Twiggs and Stacy Redican were the basis for his Nevada death sentence. Craig Miller and Mary Beth Sowers were the basis for his California conviction. The other 6 victims, including 2 children, 13 and 14 years old, taken from the fairgrounds in Reno, never had their deaths adjudicated in a courtroom. Gerald Gallego died without ever being held formally accountable for most of what he did.
Number 2. Zane Michael Floyd. It was a Tuesday morning, ordinary in every way. The kind of morning where the most dangerous thing you expect to encounter at the grocery store is a long checkout line. June 3rd, 1999, in Albertsons on West Sahara Avenue, Las Vegas. Employees were stocking shelves, helping customers, doing the quiet, unremarkable work of an early shift. Zane Floyd walked through the door carrying a Mossberg 500 Cruiser, a 12-gauge 8-shot pump-action shotgun. What followed was described by Clark County District Attorney Stuart Bell as, without exaggeration, the worst massacre in the history of Las Vegas. Floyd moved through that store. He killed Thomas Darnell. He killed Dennis Sargent. He killed Carlos Leos. He killed Lucille Tarantino. A 5th person, Zachary Emenegger, was gravely wounded but survived. There was no robbery, no specific grievance with the victims, no prior relationship with any of them. They were simply there. That was enough. Floyd was apprehended within hours of the shooting, found nearby. He did not dispute the facts: the gun, the store, the dead. He had done it. What would fill the courtroom was not the question of what happened, but the question of why, and whether why could save his life. What emerged was a portrait of a young man shaped by significant and documented trauma, an abusive childhood, severe behavioral and psychological issues that had been identified early but never adequately treated, substance abuse that ran through his adolescence and early adulthood. His defense team did not claim innocence. They asked the jury to spare his life on the basis of those mitigating factors, to see in Zane Floyd not just the act, but everything that led to it. The jury heard it all and rejected it. Floyd was convicted of 4 counts of first-degree murder with use of a deadly weapon, 1 count of attempted murder, burglary, kidnapping, and 4 counts of sexual assault. He had also committed a sexual assault against a woman in the period immediately preceding the supermarket shooting. The jury sentenced him to death for the 4 murders in the year 2000. He was 24 years old. Since then, Floyd has become one of the most legally active death row inmates in Nevada history. He has filed multiple state and federal habeas corpus petitions challenging the convictions, the sentencing, the conduct of his original trial, and the constitutionality of Nevada's lethal injection protocol. He has argued prosecutorial misconduct. He has argued ineffective assistance of counsel. He has challenged the legality of the lethal injection procedure he would face. Every court, state and federal, has denied every claim.
In 2024, the Nevada Supreme Court affirmed the denial of his most recent petition. In 2025, Floyd petitioned the Nevada Board of Pardons for commutation of his sentence to life without parole, arguing, among other things, that statutory technicalities prevented execution at Ely State Prison. The board did not grant the commutation. In April and May 2026, Clark County District Attorney Steve Wolfson filed formal motions requesting execution warrants for Floyd. The week of September 14, 2026, has been proposed as the execution date. The execution chamber at Ely State Prison, an $860,000 facility that has never been used, stands ready. The families of Thomas Darnell, Dennis Sargent, Carlos Leos, and Lucille Tarantino have waited more than 26 years. Floyd is 50 years old. He was 23 when he walked into that store. The detail that makes this case permanently uncomfortable: Floyd walked into that Albertsons without a mask, without a disguise, in plain view of every security camera and every customer present. He did not attempt to conceal who he was. Investigators have never produced a definite, documented answer to the question that has followed this case for over 2 decades. What was going through his mind in those moments before he walked through those doors? His own statements have offered explanations that courts have largely set aside. The 90 seconds inside that store remain, in a psychological sense, unexplained.
Number 1. Scott Raymond Dozier. Most men sentenced to death spend every available resource fighting to stay alive. They file appeals, they seek stays, they challenge the method, they challenge the evidence, they challenge the jury instructions, they challenge anything that might add a year, a month, a day between themselves and the execution chamber. Scott Dozier did the opposite. He was not suicidal in the conventional sense. He was not desperate or delusional or broken beyond reason. He was, by every documented account, entirely clear-eyed about his situation. He looked at the math of his existence: death row in a maximum security prison in the Nevada desert for the remainder of his natural life, and he made a calculation. He decided that dying was better. And then he spent the last years of his life trying to get the state of Nevada to agree with him. They never did. So he did it himself. Dozier was born in Boulder City, Nevada in 1970. He served briefly in the military. He was married. He had a son. By his mid-20s, that life had collapsed, and he had restructured himself entirely around the methamphetamine trade, moving between Nevada and Arizona. The killings started in Arizona. In July 2001, outside Phoenix, a man named Jason Green, known to associates as Griffin, was found buried in a shallow grave in the desert. Green was one of Dozier's associates in the drug trade. Dozier's account was that he had found Green already dead and buried the body to avoid drawing police attention to his operation. Arizona convicted him of second-degree murder in 2005 and sentenced him to 22 years. He had barely arrived in an Arizona prison when Nevada came to collect him. In April 2002, a housekeeper at a Las Vegas motel had flagged a suspicious suitcase near the property. Inside was a human torso, headless, the limbs removed. Investigators identified the remains as Jeremiah Miller, 22, a young man who had traveled to Las Vegas specifically to buy meth ingredients. One witness told investigators they had seen Miller's decapitated body inside Dozier's motel room, alongside an electric saw and additional tools. Another witness said Dozier had confided in him about the killing and had mentioned being frustrated about a tattoo on Miller's back that he had forgotten to remove before disposing of the remains. It was that tattoo investigators used to link the recovered torso to a missing persons report. Dozier maintained there was insufficient physical evidence to convict him. The jury, in September 2007, disagreed. He was found guilty of first-degree murder with robbery. On October 3, 2007, he was sentenced to death and transferred to Nevada's death row at Ely State Prison. For 9 years, appeals continued on his behalf. Then, in October 2016, Dozier stopped them. He wrote a personal letter to Clark County District Judge Jennifer Togliatti. He waived his remaining appeals. He asked the court to expedite his execution. "Life in prison isn't a life," he told the Las Vegas Review-Journal. He said there was a limit to how much artwork and exercise a person could do inside a cage. He said he had reached it.
He became what the system calls a volunteer, a condemned inmate who actively seeks his own execution. What followed was one of the most grotesque legal spectacles in American corrections history. Nevada scheduled Dozier's execution in October 2017. A pharmaceutical company, Alvogen, filed a lawsuit objecting to the use of its sedative in a lethal injection, and a judge issued a stay hours before the scheduled execution. It was the first time a drug company had successfully blocked an execution in American history by suing over its own product. Nevada rescheduled for July 2018. That execution was also blocked by ongoing legal challenges over the drug protocol. Dozier watched both scheduled dates pass from his cell. He described his situation to those close to him as limbo inside of limbo. In the weeks and months before his death, Dozier had been placed on and removed from suicide watch multiple times. His lawyers filed court documents in December 2018, arguing his mental health was deteriorating under the conditions of his prolonged confinement. The prison warden had placed him under observation in an infirmary cell weeks earlier, citing a mental health provider's concerns. In the afternoon of January 5, 2019, guards found Scott Dozier in his cell, hanging from a bedsheet tied to an air vent. He had not said anything. He had not given any verbal indication of what he intended. He was 48 years old. A prison spokesperson confirmed that had he verbalized his intention, he would have been placed on suicide watch and would have been prevented. He said nothing. The state that could not execute him also could not protect him from himself. The execution chamber at Ely State Prison, built, equipped, and waiting, had never been used. It still hasn't. The question that no official document has ever fully answered: Scott Dozier was placed on suicide watch, removed from suicide watch, and placed on an observation status that was something less than suicide watch, all in the weeks before his death. His family wrote letters to the Department of Corrections director saying the conditions of his confinement were becoming dangerous. His lawyers filed court documents saying his mental health was deteriorating. The warden acknowledged concern, and yet on the afternoon of January 5th, he was alone, unwatched. The state had been told in writing by multiple parties that Scott Dozier was in crisis. The question of why he was alone in that cell on that afternoon has never been given a public answer.